Welcome to the Agent of Wealth podcast with Mark Bautis from Bautis Financial. In this podcast, Mark helps guide you towards financial freedom, ensure you never run out of money, and create a balance in life that prioritizes what is most important to you. Join us for this journey as Mark draws from years of expertise and guest experts to solve the multiple wealth building challenges involved in your financial life.
Welcome back to the Agent of Wealth podcast. This is your co-host, John Williams. And today we're diving into one of the most common questions that we hear from clients. It's, do I need a trust? Trusts are often talked about in the world of estate planning, but many people aren't sure what they are, how they work, or whether they make sense for their situation. So today I'm joined by Tom Szieber, a North Jersey estate planning attorney. Tom has over a decade of experience helping families create tax-efficient, thoughtful, and meaningful estate plans. In this episode, we're going to break down the different types of trusts, talk about how they're structured, and give you a clear picture of what it's like to work with an estate planning attorney like Tom when setting up your plan. So whether you're looking to protect your family, minimize taxes, or just gain peace of mind, I think you'll get a lot out of this conversation today. So Tom, welcome to the show.
Thanks, John. Good to be with you.
Excellent. Yeah, I'm really looking forward to this conversation because when I said that, it truly is one of the most common questions we get. And there's a lot of nuances to this. So I'm really, really interested to dive into our conversation today. But before we get started, I'd love for the listeners to hear a little bit more about you, what drew you to law, and maybe it's estate planning in general.
Yeah, sure. I'm a North Jersey native. Specifically, I grew up in Clifton. I went to Rutgers Law School. I got my LLM in taxation from Boston University. As an undergrad, interestingly, I was a Montclair State graduate who majored in communications. So I moonlight as a part-time high school sports writer, which is always an interesting talking point when I speak to people about my professional life. You know, what drew me to law, I think, was just that as I made my way through my academic journey, I started to become more interested in the skills that you get in that industry as you're getting your education through law school and so on and so forth. I think initially I probably thought I was going to use those skills to move into the business world, but I realized I was interested in, I think initially I thought it'd be some sort of like corporate law background, but some of my early professional roles drew me to trust in estates, and it's become a real passion of mine.
Excellent. Today we're going to talk a little bit about trust. Obviously, there's a lot of different directions we could go with that conversation, but to start, I think it might just be easy for us to just break down just high level without getting into specific types of trust. Like, what really is a trust?
A trust, I think, one way to look at it is, and this is how kind of I learned it, I think, is there's three buckets sort of, and it breaks each bucket into sort of its own role when you do trust planning. So one is the settlor or the grantor, and that's the person who establishes the trust. Second, you have a trustee who is responsible for managing the assets, and they further the purpose of the trust. Obviously, the purpose can vary depending on the situation. And third, you have one or more beneficiaries, and they receive the benefit of the trust, whether it's income or principal or use of the trust property. Conversationally, the way I would describe it is just it breaks down the roles. It's not simply one individual who owns it, benefits from it, and creates the trust. It's a division of roles.
Yeah, so thinking about those three different parties, most trusts will have all three of those aspects.
And in fact, they have to, sure.
Yeah. So what is like some of the most talked about topics? Like when someone comes to you and says, like, why do you think trust is like this topic of conversation that will typically come up, and where do you think that's coming from?
So actually, pre-pandemic, I think more people with more moderate and even some high net worth individuals in terms of their wealth usually just used a standalone will. I don't know if it was because of the inefficiency of the courts during the pandemic. I noticed a lot of backlog in the court. I think there were some horror stories about how long it took to get a will probated and how assets were sort of held up for a while because individuals couldn't get executor certificates issued in an efficient period of time. And it hasn't really gone back, has been my experience so far. So courts can be slow and inefficient even in good times, but certainly when there's unique situations like that, they can be especially inefficient. And I've noticed that more people have come to me specifically wanting trust for the purpose of probate avoidance. I also think people sometimes want to explore tax savings and credit protection mechanisms that they can utilize to provide for their kids and their grandkids. And in the estate planning universe, we often say that trusts are very flexible. And we say that for a reason because there's a lot of goals you can accomplish by including a trust in your estate plan.
All right. Is there one main reason that you feel like is the most common where people come to you and say, hey, look, I think I need a trust?
Recently, it's been people wanting to just simply avoid and leave the courts out of the picture to the maximum extent possible. If I had to pick one right now, probate avoidance seems to be something a lot of people want. But again, I think people want to explore any tax savings that they can achieve. As a practical matter, people with more moderate wealth that come and ask questions about tax savings may not be aware that with the estate tax exemption so high right now, around 14 million this year and scheduled to go up, there may not be that much tax savings they need, but they still, come in and ask a lot of questions about that. People like to explore trust options for creditor protection and protection against divorces and even sometimes just irresponsible spending habits of a beneficiary. So folks come in and ask those questions to me a lot. And that's a lot of times the motivation for wanting to include a trust in their plan.
Yeah, I feel that I get the same thing about probate. And maybe like while we're on that topic, maybe for those who don't understand, and obviously there's a lot we can go into, and I don't want to go down the probate wormhole, but maybe it's important to give some detail as to what that means for like what the difference would be if someone had a trust versus like not having a trust and going into probate.
Yeah. So when you have simply a will in place, or if you have nothing in place, so let's start with the first one. If you have at least a will, your executor will have to probate that will, meaning submit it to, in New Jersey, your local surrogate's court. The surrogate's court will then, so to speak, bless the document, make sure that it meets the formalities required by state law. From that point, they're going to ultimately issue letters testamentary, executor certificates to the appointed executor, and that person can then have the authority to act to effectuate the directions in the will. If you have no will, the process is generally similar, but the individual is normally applying for letters of administration, and there are some extra steps involved with that make it a little bit more burdensome than simple probate. But in either case, you are still waiting for some period of time to get your certificates issued, and depending on how urgently your executor needs access to various assets, that can still be burdensome too. So, someone who includes at least a revocable trust in their estate plan can almost instantly access certain assets if they're included in the trust. And, there's a number of other benefits too. Something that comes up a lot that I mention to clients is that if a person is leaving assets to potentially very young people, they're going to want to make sure that those assets are in trust. And while you can create those trusts in a will, they're subject to greater scrutiny by the surrogate's court. Whereas, particularly with lifetime trusts, when lifetime trusts are established in a revocable trust instrument, I find that more useful because there's probably a greater likelihood that there's going to need to be trustee changes in the future. And that process can be completed a little bit more easily when it's done privately, meaning under a revocable trust rather than in a will itself.
Could you extrapolate on what I believe to be called like a testamentary trust, or like a trust that is actually created by a will, and like what that means?
Yeah. So like I was, I guess, beginning to touch on, you can have a will in place that simply states that you want assets that are passing via your will to go into trust for either a spouse or kids or really anybody. But those types of trusts are going to require surrogate's approval for changes in trusteeship and some other things as well. When you create those trusts in a revocable trust, that's administered privately. And so should there be a need to change trustees, it's sort of a one-page document, and you don't have to go through the steps of dealing with the surrogate's court.
It seems to me like, and I think there's a misconception that like the idea that the will can actually create somewhat of a trust. Many people, they think that, oh, I need this revocable trust, but in their more simple situation, sometimes that will creating the trust is going to be quite suffice. And I imagine that's probably a lot of times when you're dealing with clients, like the hardest thing is to decide, when do we like just rely on the will, and then when do we kind of like change over to using or like what a revocable trust is. And we'll get into a little bit about like revocable, irrevocable here in a second, but are there some things, and I know there's so many different situations, so I hate to put you on the spot like this, but there are some things that come to mind where you're sitting down with someone, and you're having that conversation, and the way that their assets are with the assets that they have, where it's like, okay, maybe we switched from relying on this will to adding that revocable trust?
Yes, there are. Sometimes people come into the office thinking that they want a revocable trust. And one thing that is a misconception, I think, to some people is that the mere creation of that trust will allow for probate avoidance. Sometimes I don't think they realize that you still have to retitle assets in the name of the trust. So there is a little bit more work on the front end with the trust. Some people come in and they realize that their administration of their estate is certainly more efficient with the trust in place. And as long as they don't mind the fact that, let's say it's their house, they're going to have to sign a deed to get their house put in the trust. And as long as they understand they're going to have to retitle bank accounts, if they don't mind doing more work on the front end, they'll often prefer to utilize a trust. If they are looking for probate avoidance and kind of don't want to do all that work on the front end, sometimes we create plans where the will is still the primary vehicle for transferring assets, but they might go, particularly married couples might go and just simply add beneficiary designation to their assets, or make sure that all their assets are jointly held, because that structure will also allow for probate avoidance. So it's very case to case. Some people come in not thinking they want a trust and will change their mind, and others will come in thinking they want one and then realize that their estate might be so simple and that the benefits of utilizing a trust are things that are not priorities to them, and then they'll just kind of stick with a standalone will.
You just touched on something that I think is really important. It's basic, but I think that understanding that there's different ways that assets can pass, through an estate or to heirs. And you mentioned beneficiaries. And in our world, when it comes to financial assets, there is a simplicity to the idea of, especially if they're going to heirs that are of age and responsible, and there's no real issues other than just getting the money to that person efficiently. Maybe we established like how, obviously we've established that the trust is a way to facilitate whatever asset you have going to your heirs, and how setting up beneficiaries fit into that. Are there certain considerations when it comes to things that don't have beneficiaries typically attached to them?
There's some clients I deal with who, we ultimately conclude that they can probably achieve everything they want by simply designating beneficiaries, because particularly on the death of the first spouse, it might be the case that if all of the assets of the married couple are jointly held, that it may be simpler just to let those assets pass via the joint ownership if the person's not interested in spending a little bit of extra money to establish a trust. I do often caution those people, though, that in the event of, let's say, a simultaneous death event, or spouse one dies and spouse two then fails to create a trust for themselves, then that there will be more assets that will need to pass through the probate process. So you can often achieve many of the same benefits, particularly on the death of spouse number one. But I think there's still a lot of good reasons to have a trust in place from the get-go, but certainly on the death of spouse number two.
There's a handful of assets that probably come to mind that like maybe jump out to you and say, all right, well, this is probably going to be something that we need to consider a trust. One that comes up with a lot with us is a primary home. Like it's usually like the biggest and one of the biggest assets outside of like maybe some sort of like collection they have, or, some things that can just, pass on through the will. With that said, like I'd like to like kind of talk about the home very quickly, and like what that could potentially mean in probate, what that would look like, and like what it could potentially look like if it was titled in a trust.
Yeah. If a home, well, starting here too, again, I'm making some assumptions that we're talking about married couples, because that's, a common, you see husbands and wives come in to do this. At least I do, more than individuals, more than other pairs of people. It's usually a married couple that comes in. Very commonly, married couples own property in a form of ownership called a tenancy by the entirety. Effectively, that just means that on the death of the first spouse, the property is going to pass automatically to the second one anyway. And there is some creditor protection that's provided by that form of ownership, because the law views it as being owned by the marital unit and not simply by one of the spouses or even both of the spouses in their separate capacities. From a probate avoidance perspective, again, on death one, there may be little difference. And so the probate of the will not affect the ability to transfer that house quickly. But in situations where you have tenants in common who have distinct interests in a piece of property, or situations where maybe it's just a single owner, when that person dies, sometimes the estate needs to be able to have the ability rather to sell the house quicker, particularly in estates where there's not much other assets, because a lot of people have just the home as their primary and the biggest asset that they have. So if the state has debts to pay or a tax obligation, they may need to be able to sell that home quicker. And there are times where it can take a couple of months start to finish before the estate has the ability to sell. So I think that's one of the things that I find that induces people to want to put their home in a trust.
So the purchase of a home, is there anything that people should be aware of to establish that tenancy in entirety to make sure that transfer to the spouse happens efficiently? Or is that something that's just like standard?
It's pretty standard. I mean, I most of the time, I think I found a lot of clients that I've had don't even realize that their house is titled that way, because there is legal significance on a deed when you see the language that says spouse one and spouse two, comma, husband and wife, or sometimes it'll say, comma, married. I don't know that some people even realize there's legal significance to that, but that language on a deed signifies the tenancy by the entirety form of ownership. Usually when I've handled real estate transactions, and I think this is the case for most attorneys, married couples, it's usually presumed that that's how they're going to own it. In a practical setting, I haven't, there are situations where, I don't know that title companies or even some attorneys even ask when it's a married couple, unless the couple expresses a desire to have distinct interests for some reason. But yeah, so nearly all the time, I don't want to say always, but the overwhelming majority of married couples that buy houses will own it in that form. And, again, sometimes don't even know it, but that language on the deed is key to understanding the form of ownership that they have.
Excellent. So let's talk second death of a married couple and, what that could potentially look like. And I'd love to hear some specifics as far as like if a house has to go through probate or no trust versus having a trust, just so the listeners have a distinction between the ease of what comes along with having that trust set up versus where if there's just a will or no will for that matter.
Yeah, if a house is held in a trust, in theory, someone can pass away on Monday and that week their successor trustee can step in. They would then have the immediate authority to begin disposing of assets. If there's not some sort of intra-family situation where the house is going to pass to an obvious person and they're required, or if no beneficiary wants the home and would rather have proceeds in hand, they can begin the sale pretty quickly. If it requires hiring a realtor, they can do that. They don't have to wait to sign a contract to sell because they already have the authority to do so as trustee. Whereas when the home is owned in the individual name of the deceased individual, it's going to require an application to the surrogate's court to probate the will. There's going to be a little bit of lag time before what we call qualification papers get sent out to that applicant. Once those are signed and sent back to the surrogate, then it's going to be a little bit more of a lag until the certificates are issued. And for a variety of reasons, the estate may need those proceeds quicker. And so it can oftentimes be more efficient and more convenient and less stressful for a family to have the house titled in trust already and, begin the process of dealing with that home more quickly.
Are there costs involved? I mean, obviously, it's going to cost money to set up the trust. You're not going to work for free. I know you're a nice guy, but is there costs involved with probate and in that process?
When I talk to clients about probate costs, in a common scenario, I don't like to be too dramatic about that. I mean, most surrogates offices that I've dealt with, the total costs are usually maybe a few $100s. There's going to be a fee to apply. There's going to be a fee to, depending on how many certificates you're asking be issued, most surrogates courts charge about $5 a certificate. So obviously pretty modest and affordable. But, if you're including attorney's fees and things like that in there, the cost can vary. I don't know that if a client comes to me and says that the sole thing that they care about is court fees, that I often steer them to a trust. I think if that was the only thing they cared about, I'd try to be as honest as possible and say that the costs are not exorbitant to deal with the surrogate's court, but there are certainly some costs, sure.
Yeah, I think that is a common misconception and just understanding and this is, let's be honest, this is one of those things where you hope you don't have to deal with a whole lot as a person or an executor or someone, someone you love passing away. And a lot of times you don't realize it until you're there, you're just like, okay, now I have to deal with this. Obviously people want to save money, but to purely just set up the trust just to avoid those costs doesn't sound like in most cases it's going to make sense.
The answer might be a little different, though, with regard to whether someone should have a will or simply have nothing, because people who die intestate, the administration of those estates can be significantly more costly for a couple of reasons. I mean, one is I've dealt with clients where a relative passes away. I guess here's the scenario, right? You've got one remaining spouse, the spouse dies, they have 5 children and no will. And now, for one child to serve as the administrator of this estate, they're going to need 4 renunciations from their siblings, since they would all, in that scenario, have an equal right to serve. So unless they're drafting them themselves or, using kind of like a standard court issued form, they're probably going to hire an attorney. They might hire an attorney anyway, but now they're going to have to pay for the attorney time to draft those renunciations. They're likely going to have to contact an insurance company to place bond. They're probably, I think there might be slightly higher costs from a surrogate, not substantially, but the process start to finish is a little bit more, it's a little lengthier rather for administration than it is for probate. So I guess I mentioned that just to say, at minimum, people should have a simple will.
Yeah, that's probably where the misconception comes in is like, obviously not having a will and the costs that are associated there. Because there's obviously 3 things going on. There's like no will, there's will, and then there's trust with a will. So I think that's great that we cleared that up. I'd like to dive in a little bit into the difference between revocable versus irrevocable. And we spoke mostly about revocable, and in most cases, especially since that because you said the level of estate taxes and the exemption there is so high that most cases revocable is where people will land. But maybe we talk just really quickly in basic terms as to like what a revocable trust is and how it contrasts with an irrevocable trust.
Sure. So revocable trusts, they're created during the lifetime of the settlor. So again, that's the person establishing it. And they are, as the name suggests, revocable. So the settlor can change their mind and get rid of it if they choose, as many times as they want. And they can establish and terminate and reestablish a new trust as many times as they want. And that is not a taxable event, in a practical sense. Sometimes you don't even know it exists because the day-to-day is not all that different than outright ownership. But the settlor, again, retains control over assets, and they're often the trustee themselves. It's considered part of that settlor's taxable estate. Therefore, it doesn't really provide any tax benefit or asset protection. Sometimes I have clients who come in and they have a misconception that a revocable trust will provide a tax benefit of some kind or asset protection. And once they find out that it does not, they'll ask, well, what does it do? It will provide probate avoidance as to the assets that are held in the trust. So again, you don't simply get the probate avoidance by creating the trust. There is a little bit more work on the front end. It does provide privacy. I can give you like an interesting war story, so to speak, is that I once had a estate administration matter where executor of the estate was someone who worked for a large company who, I won't call them famous because I don't know that the name would be recognizable to most of us, but the company would. And interestingly, they probated the will of the deceased family member, and the very next day called me a little bit concerned because they were getting phone calls from strangers, they told me. I don't know what those strangers might have wanted out of this person, but when a will is probated, it does become a publicly viewable document, sort of through the court docket. I remember explaining to that person that there wasn't a whole lot I could do about that issue, but I don't think there was great consequences, my recollection. This was kind of a long time ago. But I guess the point why I'm sharing that story right now is some people don't think privacy matters, but sometimes it can. And also, if people are disinheriting a relative or have some controversial aspect of their plan, privacy can be more important to those people. Revocable trusts also provide for incapacity planning. So when the settlor is still alive, but can't manage those assets themselves, if they are also the trustee, their successor could then step in and continue the continuity of the administration of those assets. An irrevocable trust, as the name suggests, is not revocable. So once you create it, it's, we'll say permanent with quotes around it. It can be modified in some limited circumstances as provided by New Jersey statute. But in general, you can't simply just say, I don't want this anymore and get rid of it. You are, in a very real sense, giving up control of that asset. Sometimes that can mean that there are tax consequences to doing that when you gift property into an irrevocable trust. But, the term irrevocable trust is kind of a broad term. It really includes a bunch of different specific kinds of trusts. So, for example, a irrevocable life insurance trust, we call those ILITs for short. Those are things that are commonly incorporated into an estate plan when an individual wants to have some liquidity and wants to be able to pay off estate tax. Life insurance proceeds can be used to do that. And in addition, when the life insurance is held in a life insurance trust, it's considered to be outside of the taxable estate of that person. Another commonly used irrevocable trust is we call them SLATs for short, a spousal lifetime access trust. And those can provide benefit to a spouse. But again, they are irrevocable trusts. And so they can't simply just be terminated on the spot by a grantor or a settlor who maybe changed their mind about establishing that trust.
You give me some chills here because I remember going through the CFP exam, like this area. I mean, estate planning can be, we're just touching on the surface here when it comes to this stuff. I mean, it's so complex and there's so many different areas, especially like you were saying in that like real high net worth like areas where you're trying to avoid taxation, and that's like I think when you get an irrevocable trust, it doesn't mean there aren't some wealthy individuals who should consider revocable trusts and whatnot, but I'm glad you kind of gave that distinction because especially when I'm speaking with clients, I think they think the revocable trust is doing more than there really is, and not that's not important, but it's like just having that understanding. You're not going to lose control of those assets. One of the things I actually hear, and I'd be curious to hear what your thoughts on this is like when titling. Obviously, you can title the assets and almost like they're owned by that revocable trust. One, what does that really mean, and what happens when the person dies or the grantor passes away? Like, what is like the legal kind of like switch from or the change that occurs in that trust?
The change while they're alive is generally nothing. I guess perhaps that when a individual transfers a piece of property to their revocable trust, I suppose if they had to properly sign some sort of document related to the trust property, it's more proper to sign it as John Smith, trustee. Although depending on what kind of transaction they're effectuating, I'm not sure that anyone's going to say much about it if they simply just sign their name as they normally would. Like I said earlier, on a day-to-day sort of practical analysis, moving assets into a revocable trust doesn't have a whole lot of difference from owning it outright. But upon death, revocable trusts automatically become irrevocable. They're going to then, you're going to need a separate tax ID. They're going to file separate returns. If you pass assets, let's say, to a descendant and those assets are held in trust, those assets will if structured properly, provide asset protection and some tax benefit to your descendants. To self-settle the trust and look for asset protection, commonly people will go to states like Nevada or South Dakota or Alaska that have more robust and liberal asset protection rules. But in New Jersey, at least with clients I deal with, that's normally not the case. I don't know if that answers your question. I think that those are some of the ways that a revocable trust during one's life acts and what happens when they pass away.
Yeah, that's exactly what I was looking for. Just like the transition from that revocable to irrevocable at death, and like what like legally happens there. Can the trust receive assets after death and in the form of beneficiaries? I mean, is it just suffice that you can make the trust the beneficiary of a certain asset? I imagine it's better to have it just titled, but can you actually set the trust as a beneficiary and achieve the same result?
Sure. There's sort of two things that come to mind with that question. I mean, for one, individually titled assets solely in this case, deceased person's name, estate planning lawyers are almost always going to draft what we call a pour over will. So an individually titled asset that someone fails to title in the trust name while alive is going to pour into the trust at death and then be administered in accordance with the trust terms. It's sort of like a pour over will is a little bit of a catch-all because either whether it's intentional or just an oversight, people will commonly, there'll be something left out. Some people might be really diligent and get everything they own in a trust. And if so, maybe it's not even necessary to probate a will sometimes, but commonly there's something that they are going to need to transfer via their will. And again, normally it'll, in plain English, the will would say, anything in my individual name that's not in my trust already, pour it in upon my death and distribute it in accordance with the trust terms. There are other types of assets, retirement accounts or life insurance policies, where custom language can be added on those policies. They're sort of custom forms and internal processes with the administrators or the carriers of those accounts that you'll have to go through to get this done. But you can certainly list trusts as a beneficiary of those types of assets, and those will flow into a trust as well upon death.
Now that we have let's say somebody has the trust set up and maintenance of this trust, is there some things to keep in mind? Is there, how often should someone review it, update it, and anything to add there?
As far as maintenance goes, just something that comes to mind, I guess, is that particularly for irrevocable trusts, you want to make sure that you have a team of financial folks or accountants who are ensuring that you are managing investments prudently, that you're filing any necessary tax returns. Also, with certain kinds of trusts, there's requirements to send out crummy notices on a annual basis. So there are little, what I'll call maintenance tasks that you have to complete. But and as far as reviewing trusts, in my world, we tell a lot of people that they should be reviewing their plan at least every 5 years. I will admit that that's kind of the number that was always used when I began practicing, and I never really questioned the 5-year number. But as I got more experienced, I think I kind of get it, because that is a safe period of time to assume that family dynamics might change, relationships you have with people might change. People get married, they get divorced, there are childbirths, there are deaths, and also there's changes in tax law. So I would encourage people to review their plan on a semi-regular basis. You get a lot of people that come in who say, "Oh, I have this old will from 30 years ago." It's fine. They're coming in to deal with it now, but I would review my plan more often than that.
Let's say we have some listeners here, because I kind of getting to the end here, but I wanted to give our listeners a little bit of an idea of what this process could look like. And even this is specifically to how you like to work with new clients. Let's say we have some listeners who don't have any estate planning documents in place and they're considering a trust. Like, what does that process look like, and what do you recommend, and like how's that all going to look?
At least for me, my process is that an individual will either get referred to me or call us because they sort of did a search and found us online or something to that effect. I will usually have an intro call with those people and just get a general sense as to what they believe they are looking to do, because that allows me to guide the subsequent conversations and know what questions I want to ask them. I'll send them what, in my office, we call an estate planning questionnaire that just lays out. It's not a ton of work, but I do think it allows me to analyze their situation better if I know their family structure, their health, what their asset profile looks like now and what it could look like later. And again, that frames the conversation. I'll usually then set up a consultation with those people. In my office, those are free. And then, once we land on a plan that they feel comfortable with, then, they'll formally engage with us, and then, we'll draft documents for them, and they'll get a chance to look at those and ask questions about them, articulate any changes they might want as their understanding of this gets greater. And then eventually, they feel satisfied that, okay, this is what I want. We'll have a signing take place. They'll sign their documents, and they're kind of at least finished for the moment. Again, you want to be staying on top of your estate plan, being as alert as you can to changes in tax law, and that's kind of it.
Excellent. Well, thanks for sharing that. Well, that's all the questions I have for you today. I think this is great. I really look forward to sharing this, and it's one of the things that we take very seriously in our practice, making sure that my hope is that if there's listeners out there and they don't have this stuff in the place, they either engage with you or somebody and get this stuff, because let's be honest, sometimes it's not the sexiest thing to think about. Like you don't wake up but it's really important, and so one of the things we try to do, and I'm sure you do as well, is like saying, hey, look, I know this is not something you're like excited to do, but really, really important, and just like making sure that people check that box. So I really appreciate having you on today, sharing some of the ideas here. And Yeah, I'd like to thank everybody here for joining us here on this episode of the Agent of Wealth. Before we go here, I'd love to have you share how some of our listeners could get in touch with you and some of the areas where they might learn a little bit more about you.
The one way they can do it is they can reach out to my firm, Aziz and Associates in Clifton. We also have an office in Summit. You can find my email, online. Another way is obviously potentially through you and Mark and your team, because we obviously have a good relationship. We talk all the time, and if you believe that person's a good fit for me, I always enjoy working with them. And I do have some professional social media, like my LinkedIn page, my professional. Listen, I'm a millennial, so I have an Instagram as well that I like to post some information on. Yeah, I think sometimes that feels funny to say in a professional setting, but I've actually said before to colleagues, I said, I agree that it sounds kind of far-fetched that people might find their lawyers on Instagram, but you know what? 10 years from now, that might not be as rare. So I have one of those as well. My handle there is at Szieber_Wills_Trusts_Estates. It's a mouthful, but I like to make it easy for people. So again, phone, email, social media, or just speaking to colleagues who I enjoy good relationships with. Those are kind of the best ways to reach me.
Excellent. We'll share all of your contact information in the resources section of the show notes here. Tom, I can't thank you enough for being here. This is really great. Thanks for joining me. Thanks for everyone that tuned in today. Until next time, we'll talk to you soon.
Don't forget to follow the Agent of Wealth on the platform you listen from and leave us a review of the show. We're currently accepting new clients, and if you'd like to schedule a one-on-one consultation with our advisors, please do so at bautisfinancial.com/call.
Thank you for listening to the Agent of Wealth podcast. Click the subscribe button below to be notified when new episodes become available. The information covered represents the views and opinions of the guests and does not necessarily represent the views or opinions of Bautis Financial. The content has been made available for informational and educational purposes only and is not intended to be a substitute for professional financial planning and investment advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investments and financial planning.